for you.
The park ranger has a job considerably more complex and demanding than what is often imagined. The many thousand visitors to each provincial park come to enjoy the outdoors, the local activities, and have a good time. This, unfortunately, is destined to result in a number of non-compliances and offenses occurring under provincial and federal statutes. As a result of these offenses, there is a requirement for the park officer to deal with security, public safety, enforcement, and in some instances, act as a peace officer under the Motor Vehicle Act. All these duties can severely test the park ranger's primary role of being a public relations officer. To avoid verbal confrontation, as well as maintaining an ability for self-composure, is a mandatory prerequisite for this job. What you're about to see are several vignettes designed to illustrate incidents that have and do occur in parks. You will be asked, either as individuals or in syndicates, to determine what offenses occurred, what authorities or remedies apply in the law, how you could deal with it, and that includes all the options, and most importantly, how you would deal with the situation. You will also be asked to assess the reactions of the park rangers where they actually become involved in taking some remedial action. After each scenario, your instructor will stop the videotape to allow group discussion. After group discussion, the videotape will be continued, and the situation will be reviewed by Crown Counsel Rory Morahan from the Department of the Attorney General. Now let's join our park rangers as they embark on what will turn out to be a rather eventful day in provincial parks.
We're not going to switch him that much, because as soon as he comes, maybe we'll put down.
More to the side.
You can't do that. Pick up first.
Here comes the ranger now.
Uh-oh. What's his money?
Good afternoon, campers. Just came to collect your registration fees.
Oh, how much do you want?
$6 if you're just going to be here one night.
Yeah, we're just staying the one night.
I see. Okay, well, that'll be $6, and I'll get your license number and...
Okay, you can get that out of the vehicle there.
Is there a laundromat nearby?
Yes, it's...
Is there any place the boys can swim? The kids
Yes,
can swim?
this creek is really good for swimming. Lots of nice little pools.
Is it warm?
And yeah, quite warm, and it's good fishing too. And is this your son?
Yes, it is. He's just burning off a little bit of energy. It's good for him.
The first thing to remember here, Ted, is that for parks employees, all the offenses that we're interested in seem to be under the Parks Act regulations, except for one or two Motor Vehicle Act offenses. But their authority is given under the regulations. It would appear the first thing that obviously comes to mind is the possible damage to campsites under Section 11 of that particular set of regulations. What do you think there?
Yes, I agree. Yeah.
And from that, of course, we have operating a motorcycle off the roadway. You'll note, of course, that in the other section of the regulations, I think it's 52 of the regulations, none of the vehicles, whether it's all-terrain vehicles or motor vehicles under the Motor Vehicle Act, should be off the roadways in the park, in any provincial park, of course. So there's, of course, the next immediate offense we would see. Dealing with motor vehicles, too, you might like to even go further and look at the Motor Vehicle Act. Now, of course, some of your park rangers who are designated as such have the powers of a peace officer under the Motor Vehicle Act. I should stress that these are only specific officers who have been designated to have that power. But in this particular scenario, we saw the back end of the motorcycle shooting along the park's roadway, and of course it didn't have a license on. And that means that it's an unlicensed vehicle on a park roadway. And again, all park roadways are highways under the Motor Vehicle Act. So of course the insurance and registration regulations applying to motor vehicles apply to that vehicle in the park.
Some fairly heavy fines and stuff are attached to that also.
Well, there's a minimum fine of $300 for no insurance. Now, it's a fairly important issue, too, because in the parks you'll find people walking around, walking their dogs with children, that type of thing, and if a motorcyclist went through there and hurt one of them and it was uninsured, and indeed the park ranger had allowed that, I don't know what the repercussions might be, especially if, no insurance is the safety factor that all motor vehicles have. I don't know how you feel about that.
Well, I certainly agree. I'm just wondering, what do you think about the Section 83, which is allowing the minor or child to actually commit the offense? We haven't used it very often, but with the possibility of the new uniform ticket, there's a voluntary penalty attached to that, where the parent obviously condones it and is part of it.
Yeah, as you're aware, 83, of course, has an imposition for the Crown, and that would be the park's officers, to prove that the parent had consented and condoned it. Now, in that situation, I think probably there would be sufficient evidence to establish that the parent certainly condoned it and allowed the child to act in contravention of the regulations and the Motor Vehicle Act. And of course, this is a situation that the police come into contact with often in relation to normal highways. The parents not recognizing the seriousness of the offense of allowing a motorcycle to run on the highways uninsured, etc. I think in relation to the some of the offenses, it could be used, but again, it's a discretionary matter, and it's very much left to the good sense of the park ranger, I think.
And this is where his public relations comes in as to whether or not to prosecute, and sometimes also his district manager's feelings or local policy on how to deal with it.
And of course, one of the fundamental policies you appear to have is a public relations-oriented policy, so that maybe a clear warning to that particular individual, as that is the parent, as to his responsibility. For instance, that park ranger could go up to that parent and say, well, under the Park Act regulations, you as the adult here have the responsibility for the child, and he's committing various offenses. If you continue to allow him to commit those offenses, it is an offense that you are committing. And it should be explained to the adults, because they probably don't understand either.
Okay, thanks very much, Rory. Now let's go down to the, follow the ranger down to the picnic area, day use area.
Yeah.
Okay, we got it.
Morning sickness.
Good afternoon, folks.
Afternoon.
Afternoon.
The first thing to mention here, I would think, is that there was liquor on the table, and the inference drawn from that liquor being there is that it was being consumed. Under the Liquor Control and Licensing Act, which is the operative act for British Columbia, liquor cannot be consumed in a public place. However, the evidence that the park ranger saw was insufficient to prove, beyond any doubt, which is the test that you have to use, that the people at that table were consuming. He never at any time actually saw the people at the table consuming any liquor whatsoever. So essentially, there are no offenses being committed by those individuals under the Liquor Control and Licensing Act, and therefore, being adults, they're quite within their rights to have liquor on the table. However, there is a signing provision in the Park Act, as you're aware, and any breach of the signs is an offense under the Park Act regulation. If there had been a sign that no liquor was allowed, then, of course, those adults would be committing an offense under the Park Act regulations, and then the park ranger would be in a position to explain that offense to him. I'm not sure what else the park ranger could have done. I suppose he could have explained that it was an offense to consume in a public place under the Liquor Control and Licensing Act, and warned the adults that should they have committed that offense, then they would be liable to some form of punishment under the provincial legislation. I think that's about it in that scenario.
Okay, before we go to question 3, let's see what the ranger did under this set of circumstances.
Yes.
I wonder if I could ask you not to have your bottles in such an apparent place. I've got a juvenile problem down here with that I'm going to have to cope with, and I don't want to have that so obvious. If you just put them out of sight, please.
All right.
Well, how did our ranger do in that situation?
The first thing that came to mind immediately was I asked where did he get the authority to ask adults who are legally in possession of liquor to put it away. They aren't committing an offense, as I have said. So therefore, he may not have that authority at all. However, what he did do was he failed, as I've mentioned before also, to warn them of the offense that obviously was going to be occurring, because the bottle of wine, if you saw it, was already open, and it probably had occurred. So he should have explained that the offense of consuming was a serious offense. The other thing, of course, is that he was the perfect public relations officer. But, of course, how do you keep control in a park if you're simply dealing with public relations? You have to deal with the law, and they obviously were about or had just committed an offense, though we had no proof of it. And it's incumbent upon the park ranger to act firmly with public relations and with a measure of discretion, I would think.
Okay, let's see how he does a little farther down the beach when he runs into his juveniles.
Hi, campers.
Hi.
Hello. A pretty smoky fire you got there. Anyway, it's a great day. Are you camped up at the campsite over here?
Yeah.
By the way, are you part of this group over here?
No, at all.
You're by your own.
Yeah.
I see. Okay, well, have a good time then.
Okay, thanks a lot. Bye. Bye-bye.
Hi. Anyone here 19 years old?
Hi, I hope we're not causing any problem.
Before we deal with the answers in this vignette, we'll show you how the ranger handled it.
But the problem here is that we're drinking in a public place, and that you're all except one person is underage. So I've got to ask you to put the beer away and take it back up to the campground. I presume you're camping there, are you?
Yeah.
I see. Okay. Well, I've got to maintain this. It's the law, and no drinking. And you're responsible because you're the only one over 19. So I don't want to see any more drinking of the beer, and definitely no drinking here either. Okay?
Okay.
A minor in possession and drinking in a public place. He has forgotten one, and that is the charge of supplying liquor to minors. Now, the adult there was in a precarious position. He's liable under the Liquor Control and Licensing Act for supplying. Now, further to that, there are certain other offenses that he may have considered. In that instance, there wasn't a disturbance, for instance. However, under Section 73 of the Parks Act regulations, there is the charge of a disturbance which he should consider. When the young man said that he hoped they weren't being any problem, obviously they weren't. But in situations of that nature, immediately you have to look to whether there was a disturbance earlier. Now, in any of these situations, I think the first thing to remember is that notes are of primary concern, because usually it's going to be some months later that a park officer is going to be asked by a court or by some judicial committee to recall the events, and it's going to be very difficult to recall the events without detailed notes.
Well, in this case, it would appear that the ranger is not going to take any action whatsoever other than putting the bottles away in the case type of thing, and I'm just wondering whether that is what we should be looking at in view of the fact liquor is a lot of the problem that comes up in the park.
Of course, there is another liability that may come up, and that is the park ranger is in control of the land, and is he actually allowing younger people to commit offenses related to liquor? And what is the park's liability? Let's say if those individuals committed acts against the Motor Vehicle Act, or they got in an accident immediately afterwards, if he in fact did allow them to continue on in their behavior. So in situations of this nature, I would say that it's essential to have notes of a circumstance of that nature should he be asked to recall those notes at a later date.
And he actually dealt with it very nonchalantly and was almost too nice a guy under those conditions.
Very much so, I would say. He didn't direct himself to the law at all. In fact, I would say that probably a more serious attitude should have been taken.
Okay, let's see how he makes out when he goes down to the third and last scene on the beach in Dave's area.
Hi.
Hi.
How old are you, young lady?
I'm 15, but it's okay for me to come here.
Yeah, we go camping every summer. We live in Souk.
We know that the area in question is a day-use area, so the first offense that these two youngsters are committing is camping in a day-use area. Of course, camping is disallowed in any part of the park other than a designated campsite, unless there is a specific permission gained by permit from the park ranger. So that immediate offense is apparent. They would have to, or the park ranger would have to deal with that. The next offense that might be considered is the dog that's walking around, and of course, is it under the control? Now, generally speaking, I would expect to see signs indicating that a dog should be kept on a leash. And if they were in breach of that, then they would be in breach of the Parks Act regulation related to signs. However, In the instance in question, the dog was in control of the owners, and that is the specific issue there. The next question is, of course, the moralistic question of the responsibility of a park ranger allowing youngsters, which were obviously 15 years old, to continue camping there. And that, of course, is a thorny issue which would require some great deal of discretion and judgment used on the park ranger's part. I would expect that taking the names and possibly checking them out with the RCMP would be the prudent way to deal with that matter, or in the alternative, phoning the parents to see if they in fact were allowed to be there. I think those three issues are the main ones that come out of that vignette.
I know the juvenile aspect is something that's a concern to almost all the park rangers, because they have to deal with these young people all the time. So I think that's good advice. Okay, let's go on to see what happens next.
Goldstream Patrol, Goldstream Patrol, Goldstream Headquarters calling.
Goldstream Patrol, go ahead, headquarters.
Disturbance from campsite 66. Could you please investigate this?
Yes, I will. I'm collecting fees in that area now, so I'll just continue on down to there.
I'd like to talk to whoever's registering at this campsite.
Karen, can you get your dad out of the van, please, quick?
Dad! Mom wants you!
What do you want? Oh, it's a lady ranger. Can I help you?
Again, the park ranger will be considering Section 73 of the regulations. That legislates against unnecessary disturbance in a park. And the first thing we noticed, she had to face a tremendous amount of noise coming from a stereo. Of course, this would be a disturbance. It is unnecessary, and she would have to consider at least asking this person to quiet down, or consider looking at a ticket, which she is authorized to write for that offense. The other thing that she would consider is the consumption of liquor in a park area, which is not a day-use area. This is a campsite, and under the definitions contained in the Liquor Control and Licensing Act and the Park Act regulations, a campsite becomes a dwelling house for the purposes of that particular night that the campers are there. And therefore, just like in your own home, those people are allowed to consume liquor. So no longer do the provincial acts apply. And what I'm talking about, of course, is drinking in a public place or minor in a possession. There's some discretion there that has to be utilized. The other thing I noticed was that the campsite was particularly crowded, I thought. Obviously, there were two vehicles parked there and two families. And certainly, I know there are policies that relate to the number of campers that are allowed at one particular campsite. In the circumstances, it might have been prudent not to allow the two families to join together into a party situation, and therefore create a situation where the party could blossom into something which would have been a greater disturbance than was already there. Of course, disturbances always start with conglomerates of people and probably the consumption of alcohol, and I think the park ranger's duty in many respects is to utilize discretion in allowing which campers to go together in one campsite.
It's a very difficult situation, and especially in the peak periods, July and August, where you're trying to accommodate as many people as you can. This poses quite a problem. But certainly I'm glad to see you identify it as a probable cause for the disturbance. We didn't mention the fact that eviction was possible, although in all probability under those conditions there would be no eviction, certainly on a first warning type basis in any event.
I think we may see eviction in the future.
It's certainly possible from the look of the party. It was going to look like it was going to get underway.
Yes.
Our next scenario is something that is very, very common in the parks and is something that the park rangers I know are very concerned about dealing with.
Morning.
Good morning.
Last night?
Yeah, we got in around 10:30 last night.
Okay. Maybe $6. Good evening.
Sure.
Hi, yeah, I was just wondering, is there any fishing around here, say close by within walking distance? Or?
Yes, there's some good fishing in the creek down here. It's,
okay, great.
Well, excuse me a minute, please. I'll be right back.
We got company, guys.
Stop the beer.
Good morning, campers. I'd like to have a little talk with you.
This little vignette demonstrated a very difficult problem for the park ranger. Here we have two simple offenses: possession of liquor, obviously by minors, and the other one is consuming, because as the vignette showed, one of them had the bottle to his mouth and was obviously consuming beer. However, what does the park ranger do in a situation like that? He's not authorized as a peace officer to search or to seize the liquor. So is he under an obligation, therefore, to let the juveniles or the minors continue on their way in possession of the liquor? I suggest not. There is a duty under the Criminal Code, Section 30, for all individuals, all citizens, to prevent breaches of the peace. And by breaches of the peace, I mean the Queen's peace. Obviously here, the minors were committing offenses of minor in possession of liquor, and therefore those minors are breaching the peace. As I see it, the park ranger does not have authority to seize in the legal sense of the word. However, the word used in Section 30 is to intervene in the particular acts leading to a breach of the peace. So it would appear that the park ranger would be under an obligation to intervene and stop the breach of the peace. Now, he has full authority to ask the name, the addresses, and the purpose in the park, so he can get all the details in respect of the people who are involved in the offense. And his intervention policy would simply be to prevent the continuance of the offense or the resumption of the offense after he had seen the offense occurring. Before Section 30 is used, however, the park ranger must have seen the offense occur. He cannot go on the say-so of other individuals. So once he has seen the offense, he can then prevent the continuation or repetition thereof. But, and I would suggest that the best way of doing that is to take the name, etc. of the offender, and then to take the beer from him and immediately send all the details to the police so that the police could deal with it in the appropriate fashion. And when I say the details, also the exhibit should proceed to the police department so that there could be safekeeping of the liquor. I think that's the main problem there. Of course, there is the ticket that he is allowed to write. Now, minor in possession or consuming in a public place are offenses for which he can use the new uniform ticket to summons and charge an individual with those offenses. And that might be an alternative that he would use immediately. So he'd write a ticket and then seize the beer, but not in the technical sense seize it. He would be simply intervening and utilizing the beer as evidence should the matter later go to court or go to a trial.
And that, of course, would not include search capabilities of the person that a peace officer has under the Liquor Control and Licensing Act.
That's right. You see, the park ranger, as I said earlier, is not a peace officer, and he is, in all respects, simply a citizen. when you're dealing with other individuals, except for the authorities given to him by the Park Act regulation or by the Motor Vehicle Act on those very special designated individuals. Otherwise, he must act wholly within the law, and he cannot interfere with people without the support of the law. What I'm saying is that I think Section 30 gives him the authority to intervene in the prevention of any further offenses or the continuance of an offense, and he has no authority whatsoever to search in the traditional sense that we often see police officers search on television.
Right. Okay, we have one more vignette that we're going to go to, and this is probably the most serious of them all, and something that we hope certainly doesn't happen to any of our park rangers who have taken the time and energy to sit down and watch this.
Coldstream Patrol to headquarters.
Headquarters. Go ahead, Coldstream Patrol.
I've warned that wild party of kids in campsite 68 for the second time that I'll evict them if they don't cool it. Now I'm going to stand by and just see what happens. Over.
It's from the now it's empty. Yes, it's from very
Okay, Coldstream Patrol to headquarters. I'm fed up with a bunch of campers in campsite number 68. They give me a bad time and I'm going in there to close it up. With you. You've had your last warning. I'm fed up. You're evicted. Get out now. Come on. Out. Out.
No way. Man, just let him last stand.
Listen to me, Sonny. You're going, and you're going now. Get out.
I don't think there's any problem here in defining a disturbance. We're clearly under Section 73. However, as a result of Section 73, the park ranger can enforce Section 74, which is an eviction notice. He can ask a person to leave immediately, or he can ask a person to leave within a specified time. Either way, the eviction notice is valid. However, in this circumstance, you wonder how effective an eviction notice is going to be. Should he have let the party get to such a situation that when he arrives there to evict him, nobody's going to pay attention? Probably the wisest and most prudent way of dealing with this situation would have been to prevent all those individuals arriving at the campsite and therefore starting the party and therefore allowing the whole situation to get out of hand as it obviously had. The second obvious thing that we must think of is how the park ranger lost his calm, collective nature, which we had seen earlier on in the vignettes. This time he's lost control, and as a result of losing control, he approached a situation which really he shouldn't have approached at all. Once things do get out of hand like that, I would think that the more sensible thing to do would be to call the police in, if in fact the circumstance had got so out of hand that it was interfering with the other members in the campsite. The other thing I would think about is the park ranger warning these people 3 times. What's the purpose of going and continually warning people? More valid approach, I would think, is to deal with the issue more firmly earlier on, and that, of course, coincides with my earlier comments as well.
In other words, you're saying an eviction on at least the second caution.
I would have expected so, yeah. And not allowing the thing to get out of hand. Because the continual warnings just allow things to develop further, and of course the party escalates, and then there's no control whatsoever. And that's exactly what this park ranger found himself faced with, an uncontrolled party.
Of course, we don't want him to become involved physically, but in the event that there had been a court proceedings there, and let's say that there was a charge of probably common assault against that the park ranger would lay. Generally speaking, would he be successful, even though he had basically lost his cool? Or is that a difficult situation to comment on?
Well, it's difficult in as much that you don't know how all the evidence is going to come out. However, we did see the park ranger grasp the young man first. And he would therefore have to be acting within his authority as a park ranger. I would think that Section 74 would allow him the authority to give an eviction notice. However, I'm not sure whether Section 74 allows him to grasp that individual. In fact, because of the way he behaved, it may be an assault against that younger man, because the park ranger went past his responsibilities and his duties. So therefore, when he goes in, he can tell a person to leave, but he can't grasp a person and evict a person forcibly, I wouldn't think, under those circumstances.
Well, of course, he does can use whatever force is necessary. I'm not trying to defend him, but it's just such a difficult and sensitive area that it's, I suppose, good for it not to be completely black and white.
Yeah, of course, that's what happens in all these circumstances. It's never black and white. And that park ranger went in, and it'll have to be the good sense of everyone watching that vignette to determine whether he used what force was necessary. Was it necessary to grasp that individual? And I would think not. My judgment would be that he exceeded his duty. It might have been necessary should he have given an eviction notice and told them to be out in half an hour and nobody had complied. He may then use some force. But I think the policy is to have a hands-off approach. And when the party has got so out of hand that force is required, as I understand what you've said earlier, the requirement would be to get the police in. Other offenses that we saw, possibly related to the parking of the vehicles on the roadway, you may have noted 2 vehicles parked apparently in the ditch. But there is a regulation that indicates that cars should not be parked in such a manner as to impede the normal use of the roadway. This should have been considered by the park ranger earlier in his tours of the campground to ensure that over-congestion did not occur. The other thing that we would immediately consider are the liquor offenses, of course. We've discussed those, I think, in sufficient detail. And, of course, we have also just mentioned earlier the question of notes. Now, here's a prime circumstance to show the importance of notes. How could a park ranger, when requested to set out the sequence of events some 2 months or more later, how would he be able to detail who did what without detailed notes? He would have to go back immediately after the events and write out his notes in such a fashion as it would remind him of each and every detail as it occurred. Now, the final thing I think that's worth mentioning out of this sequence is when he's dealing with the liquor offenses, he might wish to seize the liquor. Now, as we've mentioned before, there's no right of seizure. It's a right of interfering to prevent the continuance of the offense. And in these circumstances, should one of the individuals at the party said, no, you can't take the beer, or whatever was being consumed that was liquor, and was going to threaten physical violence, I think it's the park ranger's duty then to step back, because as I understand the approach, it's a hands-off approach by the park ranger, and it would be at that stage that he would phone the police for assistance.
An excellent reminder about the problems surrounding the use of force. This should reinforce our policy that we must avoid physical confrontation at all costs and make that call to the RCMP for assistance. In conclusion, it also points out the need for early detection and early intervention into this type of occurrence before it gets out of hand. A key to maintaining a peaceful park atmosphere is a prevention program which plans for and provides additional security patrols during recognized high-activity periods. Thanks very much, Rory, for joining us.
It's a pleasure. Yeah.
Hello? I'd like to register to the person.
Take it right now. Out.
I wasn't gonna say